Hello, my name is Olurotimi Osha. Today I'm discussing George Wythe and particularly his opinion in Commonwealth versus Caton, decided in 1782. His opinion in that case, laid the groundwork for the formulation of the Supreme Court uh, decision in Marbury versus Madison, which established uh, judicial review. Judicial review, of course, that opinion came from a protege of George Wythe. George Wythe, I've mentioned, was the first professor of law in America, and he was many things apart from being the mentor and teacher of Thomas Jefferson, John Marshall, and Henry Clay. He, of course, was a signer and a delegate at the convention, right, at the Continental Congress, the convention between 1775 and 1776. A delegate from Virginia. He was a mayor during colonial period, a mayor of Williamsburg. He'd been Attorney General of Virginia, and he was Speaker of the House of Delegates in Virginia. So this case that he decided, while he was also a judge, he was judge and the chancellor of the House of Virginia House of Chancery, right? High Court of Chancery, sorry. High Court of Chancery of Virginia. So he was a chancellor, that's what they were called. He was a judge, the sole judge, the sole chancellor, I think, in the High Court of Chancery of Virginia. And it was, in this position in which he served for 30 years, that he gave the famous opinion that laid the groundwork for the principle of judicial review, which his very eminent protege John Marshall, as Chief Justice of the United States, would propound in Marbury versus Madison. Now, the concept of judicial review is basically saying that if the legislature or other branches of government, it could be the executive or the legislature, if they create laws that that conflict with the Constitution, then the courts, right, can declare them null and void, can invalidate those laws. They don't have to enforce them. That's judicial review. So they have that power. That's basically what Marbury versus Madison was saying. So let me read the opinion, the words of George Wythe, Judge George Wythe, in this case, Commonwealth versus Caton of 1782. So it says, I'm quoting him now: if the whole legislature should attempt to overleap the bounds prescribed to them by the people, I, in administering the public justice of the country, will meet the united powers at my seat, and pointing to the Constitution, will declare, this is the law, right? So basically he's saying that, in another way, right, that a judge has the power, the court has the power to invalidate a legislative act that basically is overstepping the bounds established, for them, right, in their powers. So, and that's what the concept of judicial review is about. But let me quickly give the background. So it's interesting that he's talking about legislative acts. I mentioned that he'd been a Speaker of the House of Delegates. Also, they were also called the House of Burgesses, right? So, but in this capacity, he was serving as Chancellor of the High Court of Chancery for Virginia. He served in the role for 30 years. In addition to his other roles, he was a professor of law at College of William and Mary. There he taught John Marshall himself, who went on to be Chief Justice of the United States. Now, John Caton had been convicted with two other men for treason against the Commonwealth of Virginia. So, but they appealed, their conviction, their penalty was death. So they appealed they filed a petition with the Court of Appeals. There was a law in the Virginia statute, right? There was a Virginia statute that said only the legislature had the sole power to pardon an offender, right? So, and basically only the legislature had that power. And so John Caton, though, and his fellow defendants who had been convicted for treason were arguing that, by the way, so the House of Delegates had pardoned them, but the Senate refused to acquiesce. The Senate did not concur. So, under the law, both House and the Senate has to agree. Both of them have to concur, right, to the pardon. So John Caton, filed a petition with the Court of Appeals, saying, well, since the Virginia Constitution actually says that the governor and his council, right, the governor sitting with his council, had the authority to pardon. That's the executive. But there was this statute that was saying that it's only the legislature that has the sole power to pardon. And so John Caton was saying, and his co-defendants were saying that this was unconstitutional, right? That the Virginia statute should be deemed unconstitutional. Now, and that's when, of course, George Wythe famously gave his opinion, saying, well, the courts have the power to invalidate a legislative act if it does violate the Constitution. Now, interestingly, while his opinion is famous and is said to have laid the groundwork for the opinion that was now so eloquently, actually in a very in a very complicated manner propounded or espoused by Chief Justice John Marshall in Marbury versus Madison, which established judicial review. I have to be honest, many of us, it takes a long time for us to understand judicial review where we learn it in constitutional law. So in any event, George Wythe would still uphold the statutes, right? He would uphold the statutes and the conviction of John Caton on procedural grounds, because the governor had not given a pardon, right? The governor had not given a pardon. The John Caton, their interest was that they should be pardoned, and they were trying to say invalidate the Constitution of the statutes giving sole power of pardon to the legislature, but they didn't have a pardon from the governor and his council, and so it was a moot point at that at that moment. So in any event, George Wythe, in spite of his famous opinion that established that established the prototype, or was a precursor for judicial review, he upheld the conviction and the statutes. He upheld the statutes despite the fact that the Senate had not. So he upheld the statutes. So there was no pardon. Both houses had to be in agreement, both with respect to a pardon. So there you go. That's Commonwealth versus Caton, decided in 1782, and of course, so that was over 20 years, about 21 years, to Marbury versus Madison, which did establish that opinion in principle, the concept of judicial review, and basically it just means that the courts have the power to review and to invalidate acts by either Congress or an order by the executive, which we see in modern times in June, right? June, the Supreme Court, presided by Chief Justice John Roberts, struck down a federal law, an executive order by President Donald Trump with respect to birthright citizenship, which would have limited birthright citizenship, and they struck it down because it's conflicted with the Constitution, right? So, and there you go. My name's Olurotimi Osha. I will keep you posted. Thank you.